Hello, everyone, and welcome to the webinar. This webinar is on contested versus uncontested divorce, and we have the pleasure of having Taylor Brice, an attorney with Johnson Law Group, here to share his knowledge on the subject with you. As always, your participation, registration, and questions are completely anonymous, and there will be time for questions and answers at the end of the webinar. If you do have questions in the meantime and you don't want to forget about them, please feel free to type them into the chat box or the Q&A box on your screen. At the end of the webinar, I will read out those questions to Taylor to help with you guys remain anonymous, and he will answer them to the best of his ability. So without further ado, Taylor, I'm going to go ahead and turn it over to you.
Hey everyone, I am Taylor Brice, an attorney with Johnson Law Group. Just want to welcome you to our seminar, and let's begin. So it's on contested versus uncontested divorce. And I just want to let everyone know that this is not legal advice, but thank you all for attending. So what are the legal issues to consider in a divorce? There's parenting time, child support, spousal support or maintenance, assets, debt, and if you and your spouse agree on these issues, you may want to consider an uncontested divorce. How are contested divorces and uncontested divorces different? An uncontested divorce is when both spouses agree that they want a divorce and both agree on how the assets and debt should be divided in the divorce. The assets and debt will be outlined in the separation agreement, while an affidavit for decree without appearance of parties can be filed so the parties will not need to appear before a judge. Contested divorces are when people do not agree. The court will usually order mediation to see if the parties can come to an agreement on the outstanding legal issues before court. And if they don't come to an agreement, contested divorces are often drawn out as both parties and their attorneys deal with each legal issue related to the divorce. Contested divorces usually involve a judge who makes decisions for the spouses who cannot agree on the items related to their divorce. What are the benefits of an uncontested divorce? There's reduced costs and expenses. You can streamline the divorce process by agreeing to these solutions for the division of assets and debt up front, which winds up saving you time and money over the course of your divorce. There's also privacy. While the filings with the local court may be accessible to the public, an uncontested divorce allows you to keep the negotiations throughout the divorce private. And it's also faster. Once there's an agreement on how to divide the assets and debt, you can have the paperwork filed immediately with the court. This will save you time and allows the divorce to be finalized faster. The requirements for an uncontested divorce. Both spouses must be a resident of Colorado for at least 91 days. Both spouses must not share any property or must have a separation agreement that discusses how the assets and debt shall be divided. Both spouses must agree that the marriage is irretrievably broken. The spouses must not have any children and the wife must not be pregnant. While there can be an uncontested divorce with children, you have to have a parenting plan that both spouses agree to that addresses parenting time, decision-making, and child support. And then you and your spouse must sign an affidavit for decree without appearance so you don't have to appear before a judge. What's the process for an uncontested divorce? The spouses must file a case information sheet and a petition for dissolution of marriage, and it must be signed by both parties. If your spouse does not sign the petition, you must file a summons along with the petition and the case information sheet, and then these documents must be then served upon your spouse. Once the above documents have been filed with the court and there's a full agreement, the parties can draft and file their separation agreement. Do you need an attorney for an uncontested divorce? It is possible to file for an uncontested divorce in Colorado without the assistance of an attorney. It's highly recommended to have someone review your separation agreement and any other documents related to the divorce to ensure that you are not missing any potential items that could impact the process of your divorce. An attorney can also ensure that the documents are properly filed with the court, which allows you to have the opportunity for a faster divorce process overall. And that's it. If you guys have any questions, just ask them to Sarah and she can read them off to me.
Thank you so much, Taylor. Really appreciate you taking the time to speak with us. We do have one question that came in, and that is, what is the difference between joint petition and uncontested divorce?
So there's not really a difference. A joint petition can be filed and still wind up being an uncontested divorce, but you could also file just a regular petition and it must be signed by your spouse, and then you have an uncontested divorce too.
Okay, Thank you. We also have another question. How long does divorce take? Do uncontested and contested divorces take the same amount of time?
They usually don't, as long as it winds up staying an uncontested divorce. Usually throughout the process, you'll have a divorce that starts off uncontested, and then the spouses either they usually fight about one specific item or something like that, and then it winds up being drawn out, and then it winds up being a contested divorce. Uncontested divorces usually take a significantly less amount of time, because contested divorces can take probably anywhere from 6 to 9 to maybe even a year long.
Wow, good to know. And do you have an answer for how long uncontested divorces take?
It all depends. So if the separation agree, if the parties, if one of the parties retains an attorney and they file the necessary paperwork and then the separation agreement, it could be accepted with the court within maybe a month and a half to 3 months.
Oh, okay. So that's kind of the value of actually having an attorney to assist you with even an uncontested divorce.
Exactly.
Gotcha. And then another question. How much does a divorce typically cost if it's contested?
That's a good question, and it's also very hard to determine. So you have usually file the petition, the case information sheet, and the summons. Then it's served upon the other party. That usually costs about anywhere from $75 to $150 to serve the other party personally. If they waive service, meaning that I can just send them the documents without having a server actually serve them in person, that usually saves that little bit of money. Once that's filed with the court, we usually have an initial status conference where the court will order mediation, and then you have to complete your 16.2s, which is mandatory financial disclosures. And then that process can take a little bit of money and time. And then after that, you have usually another status conference to see where the parties are. And then after that, it's usually set for a permanent orders hearing. Now, preparing for a permanent orders hearing will be costly. And then depending on how many legal issues there are, it could either be a full day hearing, a half day hearing, or even drawn out longer. So it's very difficult to determine how much money a contested divorce will cost.
Thank you, Taylor. Speaking of that, if you are going through a contested divorce or you think that you might be, Johnson Law Group is happy to help. Taylor's happy to help. He is one of the attorneys there. And he can also kind of give you a better idea when he hears about your case specifically, as well as how much the retainer fee and all of that would cost. We do offer free consultations. So you can feel free to give us a call or email us, and we'll be happy to set up that free consultation. And you can even request doing the consultation with Taylor if that is something that you would like to do. Our number is 720-452-2540, or you can email us. You can email info@johnsonlgroup.com, and we will put you in contact with Taylor to answer all of your questions, and you can kind of pick his brain in that aspect. I'm going to wait for a little bit and see if any more questions come in. But in the meantime, Taylor is doing another webinar next week on the Indian Child Welfare Act. I hope I got those words in the correct order. And that webinar, it's posted on our social media, and it also was sent out via email. If you would like to register and you did not see any of those, please feel free to email us at info@johnsonlgroup.com. As always, the webinars will be posted to our YouTube channel and our social media channels after they are done. So if for whatever reason you're unable to attend, feel free to register anyways. We'll make sure you get the link, or you can follow us on social media. It's Johnson L Group LLC, or Johnson L Group, or Johnson Law Group. You'll receive an email follow-up after this with all of the links and all of that information. So feel free to stay up to all of our events and webinars by following us on social media. I do not see any other questions, Taylor. But as I mentioned, you guys can feel free to give us a call, send us an email, and we're happy to answer any questions that you may have. Thank you so much, Taylor. I appreciate you taking the time.
Yeah, thank you guys for your questions, and contact us if you need our help.
Perfect. Thank you, everyone. Have a good one.